Hi everyone, welcome back. This is Cyber Loss Problems and Solution Part 2. So we are continuing. The next topic is the next problem is related to the topic of unauthorized access to computer system, etc. So Mr. A, without the permission of Mr. B or any person in charge of Mr. B's computer, secure access to Mr. B's computer. Mr. A is liable under which section of Information Technology Act? So here, Mr. A shall be liable to pay damages under Section 43 subclause A. This section covers cases of cracking computers, computer trespass, violation of privacy, and so on. Section 43 subclause A include attempts made to access or securing access to computer system, or computer network, or computer resource without permission of the owner or any other person who is in charge of such computer system, or computer network. That is, even repeated attempts of trials to access, whether successful or not, will be covered under Section 43 subclause A. The definition of access is given in Section 2 subclause 1 subclause A. Here, access with its grammatical variation and cognate expressions means gaining entry into, instructing, or communicating with the logical, arithmetical, or memory function resources of a computer system, or computer network. To establish unauthorized access, the following features must be proved. The first one is that the computer performed a function as a consequence of seeking or gaining access. The second one, that the access was unauthorized. And the third one, that the person concerned knew that the access was unauthorized. Now, the next problem is from the topic of unauthorized downloading, copying, or extraction of data, etc. Now here, respondent was the employee of the complainant company who resigned. The complainant alleged that during his employment, the respondent copied and extracted the data of the company relating to the drawings of the National Thermal Power Plant and supplied to various persons, resulting in huge loss to the company. The complainant claimed compensation of 1 crore rupees. Examined with the case law. So here, the case law we are going to discuss is Driplex Company Limited versus Mukesh Agarwal 2010. Driplex Company Limited versus Mukesh Agarwal 2010, or JCB Limited versus Abhinav Gupta 2010. JCB Limited versus Abhinav Gupta 2010. So section 43 subclause B covers the case of digital copying, data and computer database theft, and violation of privacy. So here it is section 43 subclause B. Section 43 subclause B is an attempt by the legislature to introduce elements of copyright protection in the digital medium. It is about digital content rights. It protects data, computer databases from unauthorized downloads, copying, or extraction. So the section applicable here is section 43 subclause B, and the case laws is Driplex Company Limited versus Mukesh Agarwal 2010 and JCB Limited versus Abhinav Gupta 2010. Now the next problem is from the topic of causes introducing to computer contaminant or computer virus. So Mr. A sends a file infected by a computer virus to Mr. B, thus introducing such a virus to Mr. B's computer without his consent. As per which section of the Information Technology Act the person be held liable for the offence he committed? Here, Mr. A is liable under Section 43 subclause C of Information Technology Act. Section 43 subclause C covers any deletion, alteration, damage, or modification of any data or computer program by introducing a computer contaminant or computer resource of another person. So Section 43 subclause C takes into account 1. Attempts made to introduce or successful introduction of any computer contaminant or computer virus to any computer or computer system or computer network without permission of the owner or any other person who is in charge of such computer system or computer network. So that is with section 43C. 43 subclause C. Now the next problem is from the topic damage to computer database. Here the problem is Mr. A induced Mr. B to cause damage to the computer system or computer network of Mr. C, then Mr. A is liable under which section of Information Technology Act? So here, damage to computer database is discussed under section 43 subclause D of Information Technology Act. Damage means to destroy, alter, delete, add, modify or rearrange any computer resource by any means. Where a person induces another person to cause damage to the third person, then he is also liable under section 43 subclause D. It is important to note that damage includes both physical as well as virtual damage to any computer, computer system or computer network, data, database or any other program residing in such computer, computer system or computer network. Damage includes both physical as well as virtual damage to any computer, computer system or computer network, data, computer database or other program residing in such computer, computer system or computer network. So with respect to damage to computer database, the relevant section is section 43 subclause D. Now the next topic we are going to consider is causing disruption to computer, computer system or computer network. Mr. A, without the permission of Mr. B, does something whereby affecting the normal functioning of Mr. B's computer. As per which section of Information Technology Act, the person can be held liable. So Mr. A is liable under section 43 subclause E of Information Technology Act. That here the issue is causing disruption to computer, computer system or computer network, and the relevant section is section 43 subclause E. The section 43 subclause E takes into account attempts made to disrupt or successful disruption of any computer, computer system or computer network. Disruption here implies unexpected deviation in the normal programmed or standard operation of a computer, computer system or computer network. The next topic is denial of access to authorized person. So the first problem, Mr. A, by altering user ID of Mr. B, denies access to him to any computer, computer system or computer network whereby Mr. B was authorized to secure access. As per which section of Information Technology Act the person can be held liable? So here the issue is denial of access to authorized person, and the relevant section here is section 43 subclause F of Information Technology Act. Section 43 subclause F covers the case of any interference in the computer, computer system or computer network or any misuse of computer devices, etc. The section 43 subclause F takes into account attempts made to deny or successful denial of access to any person authorized to access any computer, computer system or computer network by any means. That is denying legitimate physical and virtual access by manipulating the access code, password, user ID, etc. by altering, modifying, dismantling or bypassing or any other means to the secured system. Now there's another problem here, that is Mr. A induces Mr. X to deny access to Mr. B to any computer, computer system or computer network by any means where Mr. B is authorized to secure access to such computer, computer system or computer network. As per which section of Information Technology Act the person can be held liable? Here, Mr. A is liable under section 43 subclause F of Information Technology Act. Here, the person who induces is also liable and who does the act is also liable. Both are liable under section 43 subclause F of Information Technology Act. Now the next problem is from the topic facilitating unauthorized access to a computer or computer system. Here, Mr. A provides any assistance to Mr. B by any means to secure access to any computer, computer system or computer network where Mr. B was not authorized to secure access. As per which section of Information Technology Act the person, that is Mr. A, can be held liable? Here, Mr. A is liable under section 43 subclause G of Information Technology Act. The section 43 subclause G is an attempt by the legislature to create an obligation for the users. This section providing any assistance to any person to facilitate access to a computer, computer system or computer network in contravention of the provisions of this act, rules or regulations made thereunder, is liable. Section 43 subclause G covers both physical as well as virtual assistance provided by any person to another person to secure access to any computer, computer system or computer network. The next problem is from the topic tampering or manipulating computer system, etc. to avail services. Mr. A is an intermediary providing services to B and C account holders. B and C are account holders and Mr. A is an intermediary providing service to both of them. For services availed by B, charges are received by the intermediary A from C by tampering with or manipulating any computer system or computer network. Explain by citing relevant section. Now here Mr. A, who's an intermediary, has acquired benefit by tampering or manipulating with the computer system. So here the section that is relevant is section 43 subclause H of Information Technology Act 2000. It covers cases of online fraud and phishing. Phishing is an illegal act whereby fraudulently sensitive information is acquired, such as password and credit card details, by a person or entity by misrepresenting himself as a trustworthy person or business in an official electronic communication such as an email or instantaneous communication. The main object of section 43 subclause H is to protect the rights of an account holder of an internet service provider, that is ISP, to prevent theft, misappropriation, fraud or forgery of access code, the user ID or password, etc. by a person on behalf of another person by tampering with or manipulating any computer system or computer network. The next problem is from the topic destruction, deletion or alteration of information. So, Mr. A by any means alters any figure given in Mr. B's computer, thereby diminishing the value of that data. As per which section of Information Technology Act, the person, that is Mr. A, can be held liable. So here the relevant section is 43 subclause I, section 43 subclause I of Information Technology Act 2000. The section 43 subclause I take into account any activity which may result into the destruction, deletion or alteration of any information residing in a computer source or diminishes its value, that is the computer resource value or utility, or affects it injuriously by any means. The essentials of computer related contraventions under section 43 subclause I are whoever causing wrongful loss or damage to the public or any person, destroying, deleting or altering any information residing in a computer resource or diminishing its value or utility or affecting it injuriously by any means. So that is with respect to section 43 subclause I. And the next topic is we have the next problem from the topic stealing, concealing, etc. of computer source code. Mr. A steals a computer source code used in Mr. B's computer. As per which section of Information Technology Act, Mr. A can be held liable. So here the relevant section is section 43 subclause J of Information Technology Act 2000. The main objectives of section 43 subclause J is to protect computer source code residing in a computer. The section 43 subclause J takes into account any activity which may result into stealing, concealing, destruction or alteration of any computer source code used for a computer resource with an intention to cause damage. The essence of this contravention is that the contravener must have caused or attempt to cause stealing, concealing, destruction or alteration of any computer source code. Now, computer source code means the listing of programs, computer commands, design and layout and program analysis of computer resource in any form. If any person without the permission of the owner or person in charge of any computer system or computer network steals, conceals, destroys or alters such computer source code intending to cause damage, then he shall be liable under section 43 subclause J of Information Technology Act 2000. Now the next problem is from the topic privacy violation, that is obtain evidence to support a criminal proceeding. Now here a case law is explained, that is Vinod Kaushik versus Madhavika Joshi 2012. Vinod Kaushik versus Madhavika Joshi 2012. The Vinod Kaushik versus Madhavika Joshi 2012, the complaint was filed in 2010 for privacy violation committed between 2008 and 2009. The complaint was made against the complainant's daughter-in-law, who is the respondent, who was estranged from her husband, the complainant's son. In September 2010, the then adjudicating officer dismissed the complaint after finding that, owing to the marriage between the respondent and the complainant's son, there was a relation of mutual trust between them that resulted in the complainant and his son consensually sharing their email account password with the respondent. Subsequently, appeal was filed before the Cyber Appellate Tribunal, which gave a decision in June 2011 and found irregularities in the complainant's son's privity to the proceedings and remanded the complaint to the adjudicating officer for re-adjudication. During the re-adjudication, adjudicating officer found that the respondent had violated the privacy of the complainant and his son by her unauthorized access of their email accounts and sharing of their private communication, which amounted to cyber contravention under Section 43, Subclause A. However, the adjudicating officer found that the intent of the unauthorized access to obtain evidence to support a criminal proceeding was mitigatory and hence ordered the respondent to pay only a small token amount in compensation, not to the complainants but instead to the state treasury. The appeal was filed before the Delhi High Court, which was moved in appeal because Cyber Appellate Authority was non-functional, upheld the final order in its decision of 27/1/2012. So what happened here was the complainant was the father-in-law and the respondent was the daughter-in-law. So after marriage, the email address and password of the husband and father-in-law was given to the wife consensually, and she used it to secure evidence for a criminal proceeding. So with that, the court held that though it is wrong, it is a violation of privacy, but the intent was to prove to get evidence of a criminal proceeding. So she had to pay a small, she was directed to pay a small fine, not to the complainant, but to the state treasury. So that is the case of Vinod Kaushik versus Madhavika Joshi 2012. The next problem we have is from cyber defamation. Jogesh Quatra, a plaintiff's company's employee, started sending derogatory, defamatory, obscene, and abusive emails to his employers and also to the different subsidiaries of the said company all over the world. This email were anonymous and frequent and were sent to associates to tarnish the image and goodwill of the company and its managing director, Mr. R.K. Malhotra. Does this come under cyber defamation? So here, section 66A, 66 capital A is applicable. And we have a case law, that is a decision rendered by Delhi High Court in SMC Pneumatics India Private Limited versus Jogesh Quatra. SMC Pneumatics India Private Limited versus Jogesh Quatra. Here granted an injunction and restrained the employee from sending derogatory, defamatory, obscene, and abusive emails either to the plaintiff or to its sister subsidiaries all over the world, including their managing directors and other concerned departments. Now, sending of offensive message through communication service, etc., that is brought under section 66 capital A and covers all activities through which a person sends a message to any other by means of a computer resource or communication device which is offensive or coercive, false, and cause annoyance, inconvenience, danger, insult, injury to another person, or an email or electronic mail sent to deceive or mislead the addressee about the origin of such message. So any of such message sent through a communication or electronic communication device is brought under section 66 capital A of Information Technology Act 2000. Now again we have one question from cyber defamation, that is publication of defamatory material against another person with the help of a computer or the internet, that is social media or messaging channels or emails, is known as cyber defamation. If someone publishes a defamatory statement about a person or an entity on a website, social media or messaging channels or sends email containing defamatory materials to another person or an entity with the intention to defame other person or the entity about whom the assertion has been made, that amounts to cyber defamation. So, cyber defamation in Indian perspective, Section 469 of IPC. Section 469 of IPC says that whoever commits forgery intending that the document or electronic record forged shall harm the reputation of any party or knowing that it is likely to be used for that purpose shall be punished. Then further, section 499 of IPC, which is related to defamation. Now 499 of IPC says that whoever by words either spoken or intended to be read or by signs or by visible representation makes or publishes any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is liable, and that is defamation. Now section 503 of IPC. Section 503 of IPC. Here say 503 of IPC says that whoever threatens another with any injury to a person, reputation or property, or to the person or reputation of anyone in whom that person is interested, with the intent to cause alarm to that person or to cause that person to do any act which he is not legally bound to do, or to omit to do any act which that person is legally entitled to do as the means of avoiding the execution of such threat, commits criminal intimidation. So a threat, if you are threatening someone to do or not to do something by using a defamatory article or something of a defamation in hand, that is criminal intimidation. So, with respect to IPC, defamation is dealt in 469 IPC, 499 IPC, and 503 IPC. In 469 IPC, it discusses about forgery of a document which is used for defamation. 499 defines defamation, and 503 of IPC used where a defamation is used as a threat to make a person that is directly to the person or to someone the person is interested in, to make that person to do or not to do something. So criminal intimidation by using defamation as a threat. Now the next topic we have is cyber defamation and intermediary. We have the question from cyber defamation and intermediary. Here, an Indian online intermediary receives for its bulletin board an article written by X in which some defamatory statements are made against Z. Here, A puts up the article on the bulletin board and Z sues him for defamation. What is the law which will help Z and hold A liable? Since the defamatory matter appears on the internet, A will seek protection under Section 79 of Information Technology Act 2000. So, A will seek protection under Section 79 of Information Technology Act 2000, claiming exemption. Here, supposedly, A draws an analogy between publishing of information which is obscene in electronic form and publishing of information which contains a defamatory statement. Legally speaking, how far A will be allowed to draw the analogy regarding the word publishing, which is appearing in Section 499 IPC, which defines defamation and which is already giving immunity to A as an online intermediary when it appears in the context of Section 67. There appears to be no legal hardship in such analogy as defamation. Like obscenity is an offense which is breach of one's privacy and is also an antisocial offense, and thus these two offenses can be read justum generis. Thus, in the matter of the internet defamation, A can conveniently take the defense of Section 79 where the incriminating matter is any third-party information or data. The question then comes whether A was aware of the contents of the matter. Section 499 of IPC defines defamation as defamation whoever by words either spoken or intended to be read or by signs or by visible representations makes or publishes any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is said except in the cases hereinafter accepted to defame that person. Section 499 requires three elements. The first one, making or publishing imputation. The second one, such imputation must be made by words. The third one, either spoken or written or read, signs or visible representation. The keywords in A's case are making or publishing and is to be seen whether A as an online intermediary here is to be held liable for it. As the matter is originated by X, will A also be liable for making it? Here, if it is proved that A had no knowledge of the contents of X statement, then he is not said to make the statement. But as A had put it up on the bulletin board, what will be his position? Will he be regarded as the publisher of the material? So that are the issues here. Now, the publisher of a newspaper is responsible for defamatory matters published in such paper, whether he knows the contents of such paper or not. This was held in Empress of India versus Macleod 1880. Empress of India versus Macleod 1880. In this case, it was held the publisher of a newspaper is responsible for defamatory matters published in such paper, whether he knows the contents of such paper or not. Reading the above two provisions together, it is to be examined as to what the position of A as an intermediary is, whether A exercised editorial control over the contents which he places on his bulletin board. If it is true, then it is immaterial whether A actually exercised this control in respective of incriminating attempts against C. So what it says is here that if I had any control over the things that are being posted on online bulletin board, then A will be held liable. It is immaterial whether he did exercise that power or not. If he had the power to do so, he is liable for it. He should have done that. We have a very similar case in another one where in an online bulletin board, the ad for obscene materials were published. In that case also, the court held that when the subscribers submit certain, the facts of the case is that there was a online bulletin board and people could post their photos there. But it is like a pooling of photos where people can upload some photos to download some photos. So some subscribers uploaded some obscene photos, and this was brought before the court, and the court held that when there was a control mechanism set by the website, that the website administrators had to accept, go through the photos, check its veracity, and then accept it to the online bulletin board to permit the users to free pass for a few days or the extended free pass. So there they had the right to control what is being posted, but they did not exercise it. So that is not a defense here. Since they had a control, it is immaterial whether they exercised it or not, they will be liable. If the intermediary had control over the uploading or posting of such post in the bulletin, then the intermediary will be held liable, no matter if they exercised that right or not. So in another problem, plaintiff, one of the biggest fast-moving consumer goods companies, that is FMCG, fast-moving consumer goods companies in India, and one of plaintiff's products, Parachute edible coconut oil, was claimed to be amongst the most reputed brands owned by the plaintiff. Defendant, a YouTuber, had his channel titled Bearded Chokra. On or about 1st September 2018, defendant published a video titled Is Parachute Coconut Oil 100% Pure? In this video, defendant reviewed plaintiff's product. In the mentioned video, the defendant is forceful, decisive, and assertive with his words and statement against Parachute branded coconut oil. He explains that it is one of the most sold and consumed coconut oils in India, and that he was going to break down all the tiny details about the product and bring the truth to the viewers. plaintiff filed the present suit claiming that defendant made false claims and statements about the plaintiff's product. So this is the next problem, and here also we have the same so the have YouTubers has a control mechanism. So the question is whether the YouTubers is held liable or the plaintiff or the person is held liable. So here uh, that we can a fixed answer is not given, so we can approach the question in two ways. In one way, the YouTubers do have control on the over the content, so we can hold them liable. But it is also to look upon that what are the criterias of control they have. Usually it is on the copyright. I don't know about the what kind of controls YouTube have. So normally they do have copyright controls. So and if whether it is made for kids or not, depending on the content, depending on that, if there is obscene materials or if it is okay for the kids to watch, you do have such controls over YouTube. But I'm not sure about the such as to such about reviewing of product. So I think we can use the same question, same as in Empress of India versus Macleod, and represent both the sides of the control here. I'm sorry that I don't have a perfect answer for this because I don't know about what kind of editorial controls does YouTube have. So that is with part 2 of cyber laws problems and solutions. We still have a lot more of questions going on and from different topics. So that will be there in the following parts. And I hope I can answer almost all the questions and this is useful for you. And with that, this is the end of part 2. Thank you so much for listening to me. If you have any doubt and for if I have missed out anything and if you know the answer, please let me know. And just right now, there was no, I couldn't provide with a good answer for one problem. If you have answer for that, please let me know in the comment box. And if you have any suggestion of how I can do a better give you this video status, if I am too fast, if I am too slow or whatever, any feedbacks, please drop in the comment box. Now like, comment, share and subscribe. Please do subscribe so that I can keep posting videos, and stay tuned for any update of my next upload. Thank you so much everyone. Have a good day and bye.